SJC-12401, Holyoke Mutual Insurance Company et al. v. Vibram USA Inc. et al.
Mr. Wright, good morning. This is the first time this court has addressed the great Abibi Bikila before, the greatest marathoner of all time, so it's a pleasure. Go ahead, you may proceed.
Thank you, Chief Justice. Good morning. We're still in the morning. To you, Chief Justice, and to all the justices. May it please the court, my name is Stephen Wright. I represent Vibram LLC, Vibram USA LLC, and Vibram Five Fingers LLC, who's the policyholder in this matter. Essentially, this appeal can be boiled down to two issues. The first issue has to do with whether or not Holyoke Mutual and Maryland Casualty owed a duty to defend under their general liability policies to the Vibram entities, well referred to as Vibram. The second issue has to do with how that duty to defend works, and in particular, what to do with defense costs in the event that there's a declaration that there is no coverage. In particular, here there are sort of two issues. One is, does that payment obligation continue up to the point there is the declaration? That's one. And then the second is, what happens in the absence of policy language providing for recoupment when carriers ask to recoup the defense costs that they have paid?
Well, the first issue is a coverage issue, obviously of great importance in this case and maybe some importance beyond it. But the second issue is gigantic. It's a huge issue, and we don't have much law on it.
That's correct, Your Honor. The second issue, I'd prefer to address the first issue first, really for the purposes of the fact that for this case, for Vibram, if that issue is decided in favor of Vibram, we don't even get to the second issue. And it's a complicated issue in of itself. The second issue, of course, is also complicated and has an impact throughout not just this Commonwealth, but through other states as well.
And I guess my issue is, this is all about looking at the underlying complaint.
It is.
And the gravamen of the underlying complaint is, at least your brother's saying, is a right to publicity. And now you're involved in this litigation, and all of a sudden we're looking to see if this is an advertising idea. Mm-hmm. So why is it an advertising idea?
Well, the way that the advertising injury grant of coverage works is essentially there are three different ways to obtain coverage for the purposes of this case: advertising idea, right of privacy, and infringement of a slogan. So the majority of the opinion below really focused on the advertising idea prong. It matters here because essentially there is coverage for the use of another's advertising idea in your advertisement. Here, the Bikila family, in the underlying complaint, alleges that their advertising idea was subsequently used by Vibram. Therefore, there should be coverage.
That's not what Justice Kaplan found, right?
Right. Justice Kaplan focused on this as a right of publicity.
Well, no, I think he did address, my memory is, what the family had done in Ethiopia and found that they had not used their Mr. Bikila's name for advertising purposes. That they had a sporting goods store, they had a marathon, but they didn't use his name for advertising.
Well, I think that isn't properly looking at the complaint below. I think that truthfully, the judge, the way that he looked at it, he said this is basically about publicity.
Right.
This is about the Abibi Bikila name. So what the court should have done is actually look at the allegations that were pled in the underlying complaint. That's the touchstone for coverage here. The allegations in the underlying complaint allege that the family made commercial use of the family surname, and they pointed to specific examples of doing that, including running a sporting goods store that sold, presumably amongst other things, running shoes. They also used it.
Do we know the name of the store?
I don't know the name of the store as I sit here today. I don't believe it's actually pled in the underlying complaint.
How's that an advertising idea?
Well, an advertising idea is it's a very broad, sort of nebulous concept. It's, to use I believe this is the language that's used by my brother in his brief. An advertising idea is an idea used to solicit business.
And it's
Period.
given a broad interpretation in Deutsche Bank.
It is. Oh, and
And I imagine the definition is more favorable to the insured than the insurer.
that is the rule for insurance coverage, is that the definition should be read in favor and broadly for coverage. The briefing here tries to really slice what advertising idea means. And there's a trip down trademark law, looking at secondary meaning, looking at all these different kinds of things. The cases that actually address advertising idea that are most analogous to this case don't mention secondary meaning. They don't mention this particular area, this elusive concept under trademark law. Instead, they look at the policy language. The policy language says use of another's advertising idea in your advertisement, period. Advertising idea itself is not defined. Again, to take the definition that's used by my brothers, advertising idea is an idea used to solicit business. It's very broad, very broad.
Yeah, but, good.
No, go ahead.
Yeah, but when you look at how the family used their relative's name, and then you look at the advertising here sort of the message is a minimalist running shoe, and you associate it with this name because of obviously the history of running a marathon barefoot. You can't really find that in the underlying complaint. I get the sense when you look at the underlying complaint, it's like Kareem Abdul-Jabbar being upset in the Ninth Circuit case with the company GM or whatever company it was using Lou Alcindor. Mm-hmm. And that's the sense you get from the underlying complaint.
Well, I think that's actually, it's different in this particular case.
Rewind, please.
Because Lou Alcindor, Kareem Abdul-Jabbar, was not using Lou Alcindor for anything. So his was sort of pure publicity right. I would prefer if people didn't use Lou Alcindor to sell Oldsmobiles, okay? We can understand that concept. Here, in the underlying complaint, the Bakila family alleges that they made commercial use of their surname. Abdul-Jabbar did not do that. So that's really the difference. And there aren't a ton of allegations, I will admit that. However, the allegations are sufficient to bring this into the grant of
Can you
coverage.
be more specific for me and tell me what exactly it was that they did allege about commercial use of the Bakila name?
Sure. Well, they said that they made they talked about what the family did and the things that they did with the name. The commercial uses, the term commercial uses is into the underlying complaint. They've essentially associated the family name, that is Bakila, with baby Bakila's barefoot dedication to succeed under any circumstances. And then they point to the specific things that they've done, be it running a sporting goods store, be it sponsoring a marathon in Ethiopia, be it publishing a book and making those uses. So it's different. It's fundamentally different from the Kareem Abdul-Jabbar example, which, by the way, is not a coverage case. That's looking at Lanham Act, and it's looking at a variety of different claims that are made without looking as to whether or not there's coverage available. So it's not really an advertising idea case.
So for all practical purposes, you are saying that whenever if Habibi Bakila simply was a great marathoner and was unhappy that his name was being misused, he would not be able to get insurance coverage, or you would not be able to get insurance coverage.
If he was simply going on his name alone, he needs to demonstrate that there's an actual advertising idea.
So where there is, frankly, any business, even one that's in Ethiopia, and even one that's simply a sporting goods store and a marathon, that is sufficient to transform that into an advertising idea for purposes of coverage.
Right, that's true. And one way to look at
Or
this
purposes, I should say, of a duty to defend. We haven't reached the issue of coverage. We don't need to reach the issue of coverage.
That's the correct point, Your Honor.
Can I ask about follow-up? I mean, Vibrant's clearly using his name as an advertising idea, right? There's no doubt that they are.
Correct.
And they're suing him for using his name in an advertising idea. So they need to have done it themselves, I take it, to make you steal their advertising. I'm just wondering if it's like a bad advertising idea claim that they have, and the slimmer their claim, even though you're using, there's something weird about this.
There is. And it's partly because advertising idea is a very broad concept.
But we know from Vibrant's perspective, they're using his name as an advertising idea. And then they're saying you're using our name as an advertising idea, so we must have been using our name as an advertising idea, right?
Well, one way that I can perhaps demonstrate this for the court, sort of the subtlety here, is that there is a case that's cited in the brief. It's the Taco Bell case. And it's some sort of notion of the advertising idea there is psycho chihuahua, okay? An advertising agency came up with the idea of a psycho chihuahua. They shared it with Taco Bell. Taco Bell ended up using it essentially without paying the agency. The agency sued.
But that's an easy case, right? Because that's clearly an advertising idea by both sides, right?
But they never used it. The advertising agency never used Psycho Chihuahua. They never went out in the market and said, we've got this great advertising idea. They had the idea was taken, and they complained about it.
And the coverage was under the same kind of provision?
Yes, yes.
Now, you probably can get away with not getting into the slogan issue, but you haven't addressed the right to privacy issue. And the right to privacy issue runs into an intellectual property exclusion problem, doesn't it?
It does. From Vibram's perspective, the only, that particular exclusion, the other intellectual property exclusion applies to the privacy, the right of privacy prong here, the coverage that's available under that particular prong.
So you're putting all your eggs in the ad idea basket?
Not at all, Your Honor. Vibram is arguing that there's coverage under advertising idea, right of privacy, and slogan, all three.
And you want us to apply Washington state law?
Correct, Your Honor.
What's the slogan? I'm confused. What's the slogan?
Tequila.
Tequila is a
Single
name
word.
is a slogan?
A slogan is a catchphrase. It can be a single word.
I mean, I understand why Air Jordan is a statement, but is Jordan, Michael Jordan, you just use the name, that becomes a slogan? Your name can be a slogan?
A name can be a slogan. It
Yeah,
just
but
needs
there's
to
a
be
reason you
catchword.
have slogan as your third argument. What about Washington State? Because the insurers are just going to say, all right, apply Washington State, it's the same. And you know all the cases that they go through from the Washington State Supreme Court and the United States District Court saying that there's nothing there. That it's the same as Massachusetts when you're dealing with the right to privacy.
Well, it's not.
I know, and you tell me why.
Sure.
the
The
restatement-
three key cases, there are two Supreme Court cases, the Reed case and the Eastwood case. Both recognize a common law right to privacy, which includes within it an appropriation right of privacy. So essentially what's alleged here is that there's been a violation of the Bacchila's family right to privacy by appropriation of his name.
Even though that's a separate tort, the right of publicity?
In Washington State, there's a statutory protection. That statutory protection does not overrule or otherwise change the common law right that's available, and that's discussed in the Reed case, the Eastwood case, and in the federal court case, Aronson.
Why shouldn't an insurer have a right to recruitment? If there's no allegation that falls within the coverage, then why can't they recoup what they put out if they decide to defend with a unilateral statement?
Well, First of all, Massachusetts has a conception of how broad the duty to defend is, and it's consistently stated by this court as being broader than the duty to indemnify. So it's different on its face. That matters a lot because most of the cases that my brothers cite or try to rely on that are actually decided in this state do not touch on the duty to defend. A more important issue here, and that could be dispositive, and as far as the trial court was concerned, it was of great importance, is that this policy does not include any language granting them the right to recoup.
Doesn't include any right to what?
It doesn't include any language granting them a right to recoup defense costs.
That's a pretty important issue, considering there's another provision that says that the policy controls all issues.
Correct. And in the briefing, we noted specifically that there are ISO forms that are available and could have been used by these carriers that say that the carrier has the right to seek reimbursement of defense costs or recoup defense costs.
But aren't you rewarding people who don't pay? I mean, you got a duty to defend, and if you don't pay, you don't have to pay. I mean, I don't understand that. I mean, if you have a duty to defend, wouldn't you have a duty to defend all the way up to the judgment? And we really don't want people not to pay their lawyers, do we?
No, we don't. We don't want carriers not to fund the defense when they have the obligation to fund the defense. And that's one of the issues that actually arose here, in that essentially the carriers unilaterally and without explanation stopped paying before they even obtained the declaratory judgment on coverage.
Can't there be a duty to defend that's much broader than there being coverage? I mean, sometimes, because there's close issues.
Right, and that's true. That's actually the state of the law, is that the duty to defend is broader than what ultimately could be covered. So it's not uncommon for there to be a duty to defend, but not a duty to indemnify a settlement or judgment that arises out of a particular claim.
And doesn't get a duty to defend, then you shouldn't get a recoupment.
Correct. And that position is consistent with pronouncements that have been made by this court in Morrison, in Deutsche Bank, and in Auto Flat Crushers. Tellingly, those cases, 2011, 2013, 2014, we're talking about law that is very much on point as far as how this court sees the duty to defend.
Well, it's not on point. I mean, it's a disability case.
Well, no, those cases are on point in the sense that there's discussion about about essentially how the court views the obligation to continue paying defense costs, and that it doesn't apply retroactively. That's the quote from the Morrison case, which is built upon in the Deutsche Bank case, and then both of them are quoted in the Auto Flat Crushers case.
Your view is it's a simple rule, right? If they have a duty to defend until the declaratory judgment, all the fees incurred up till then have to be paid, right?
Correct.
But if they don't have a duty to defend, should they get their money back?
They get their money. They don't get their money back. They can. Their option is to go to the court and obtain the declaratory judgment. If they obtain the declaratory judgment, then prospectively they don't have an obligation to defend. And that's been the state of the law in Massachusetts, and it would be consistent with the law as announced by 7 other highest courts.
So if the duty to defend only went up to the determination of whether or not there was liability, but all the payments hadn't been made as yet, and then you didn't get the payments that you had to put out for your lawyers, then you're going to get awfully slow payments, aren't you?
Yes, there's certainly a public policy concern that's associated with that kind of slow
Maybe
payment.
incremental payments?
Incremental. This is a perfect example of it in the sense that the last payment made by one of the carriers was in January, and the decision didn't come out until August. So this is a significant amount of time. As a matter of fact, it's $604,000 of defense costs that predated, that were incurred but weren't covered by the carriers before the DJ was.
So it's the declaratory judgment date that's the key date.
It is. Should the court find that there's no coverage in this case.
All right, thank you.
Thank you.
Counts. Good afternoon, Mr. Chief Justice.
Good afternoon, Mr.
and
Giacola.
Your honors. I want to split our argument time between me and my brother, Mr. Reisberg. I will argue the duty to defend issue that is the subject of Vibram's appeal, and Mr. Reisberg will argue the fee and recoupment issues, which are the subject of the cross appeals. And we're asking for equal time. I think I can safely say that this case is quite different from what you've heard so far today. It's about one word: Bikila. The question is, what is Bikila? The answer will determine how the court decides the duty to defend. What do we know? Well, we know that Bikila is the surname of the plaintiffs, who are the family of the famous marathon runner from the Olympics in the 1960s, Abibi Bikila, who won his events running barefoot. But it's got to be something else for there to be coverage. And Vibram, I think, is in the position of a game show contestant, looking at 3 doors and hoping that Bikila is behind one of those doors. Advertising injury?
Well, but he is,
Logan.
he is their advertising idea, right? There's no doubt about it. His name doesn't just symbolize a person, it symbolizes a person running fast barefoot, right?
Correct.
Otherwise, they wouldn't have put his name on their shoe.
Vibram would not have.
Right.
Correct. That's
So-
their advertising
So they're
idea.
clearly using it as an advertising idea.
Right, and it's
then
even more specific. They're associating him with their shoe because their shoe was the first shoe to have toes.
Right, I get that. So, and then the question is, did you use him as an advertising idea, right? You're saying he's just a person, not a symbol or an advertising idea, right?
The question is, what did the Bikila family do?
Right.
Actually,
Bikila name.
it's actually what they alleged in the underlying complaint.
Yeah, and Your Honor, I want to refer you to the appendix at pages 232 and 233. Those 2 pages are the evidentiary record, because those are the allegations by the Bikila family themselves as to what they did with the name Bikila. And in answer to the earlier question of did they name the store, the name of the store, I allege in paragraph 25 that from approximately 1980 to 1990, the Bikila family operated a sporting goods store in Ethiopia named after Abibi Bikila. So I guess we can assume that the name of the store was Abibi Bikila.
So isn't that advertising, his name? Because they didn't name the store Good Shoes, they named it Bikila. Aren't they advertising, using his name as an advertising idea by doing that?
That gets to the heart of the case, Your Honor, because when you look at the rest of the complaint, the Lanham Act claim, the Washington state law claim.
Stick to the advertising idea, because it seems like the central part of the case.
It is.
Yeah, and can I just echo that, please? I mean, you know, the slogan issue seems a bit of a reach, and we've got, at minimum, a complexity with the right to privacy on what state, and also there's an exclusion. So I completely agree with Justice Kafka. The time's well spent on the advertising idea.
Well, what are the advertising ideas alleged by the Bikilas? They used it for a store that they operated for a decade. They wrote a book about their father, honoring him. He was featured in a Japanese commercial with permission by the Bikila family. He was the subject of a feature film about their father, released featuring the final years of Abibi Bikila's life. And they've operated a website which contains pictures, videos, news events, and information on current races, such as the Abibi Bikila International Marathon, held in Ethiopia and sponsored by the Bikila family. And they talk about why they do it, and the association they want to make is between their father, their activities, and his dedication to succeed under any circumstances, his barefoot dedication to succeed under any circumstances.
What does
There's
that
nothing here that sounds like what Vibram took.
What does that mean, though, that his determination, isn't that what they're saying? They're saying that I mean, isn't there an overlap between those two concepts?
I don't believe there is, Your Honor, because the actual advertising idea here, if there is one in this case, is a sports hero's endorsement, because that's what they're complaining about. They're saying, we're suing you because you used our father's name without permission, and that suggested that we or he endorsed your product. That's the complaint. It's endorsement. The advertising idea is celebrity endorsement. That's an advertising idea, but it's an advertising idea that's in the public domain. Lou Gehrig appealed on a Wheaties box in 1936. I'm old enough to remember Bob Cousy on the Wheaties box in 1956. Tom Brady is a perfect example of celebrity endorsement. He's endorsed dozens of products, including 2 lines of watches, Movado and Tag Heuer, Wheaties and Dunkin' Donuts, 2 lines of cars, Cadillac and Aston Martin. He endorses these products. Is his endorsement of that product an advertising idea that Tag Heuer took from Movado?
They don't call those the car isn't called the Brady. It's called the Aston Martin or whatever it is.
Correct.
And when Roger Federer is advertising coffee, it's not Roger Federer coffee. There's some reason to use his name. It's different than endorsement, isn't it? And
Well,
it's
that
also
comes up
because
with-
he's so special too. It's this connection of bare feet to their barefooted product.
But it's still just an endorsement. It's not an advertising idea. They didn't create a Toad shoe and said, this is the Tequila, and they took that advertising idea. There's no allegation that they even had a running shoe or any sports apparel. They had a sporting goods store. There's no allegation that they were selling Tequila marked products or anything like that. It's just too much of a stretch to say that the activities described by the Tequilas in their complaint.
See, to me, it seems like the Tequilas don't have much of a claim, but the claim they're making is really an advertising claim. Because they don't have much to work with. Then they're bringing the claim that these guys bought defense insurance for. That's why I'm troubled by this.
Let's go with their own words, Your Honor. Under their false designation claim under the Lanham Act, they allege that the defendants created a false designation of origin and a false representation of origin, source, sponsorship, endorsement, affiliation, and authenticity of the infringing products, creating a likelihood of confusion in the consuming public. Their actions are likely to create confusion among the consuming public and is intended to confuse and defraud them into believing that Tequila and the Tequila family produces, sponsors, or endorses Vibram's products.
But
That-
but an advertising idea is really broadly defined, and maybe when they're crafting the complaint, they're thinking of a right to publicity. But we know that there's a lot of cases, including the 11th Circuit case. I can't remember the name of it. That really says is just a advertising idea is to promote a product. That's pretty broad.
That's pretty broad, but Your Honor, I think, again, that is the advertising idea at issue here is what is the advertising idea? Is it the Tequila name is Tequila, standing alone, because that's all there is. Is that an advertising idea?
Yeah, well, the idea is it an advertising idea? Look at how this guy's fortitude and look at how little he needed by way of support when he was running, and look at this Tequila. And that's the idea behind.
That's their advertising idea, Your Honor. Their advertising idea is look at this shoe with the toes, and that echoes his barefoot feet. That's their advertising idea. That's not the Tequilas do not allege that they used that idea, and that was taken from them. What they allege is you used our father's name.
Which they were using for a marathon in Ethiopia, using for a book, using for a sporting goods store that was around for, I think, a decade. I mean, the family's using the name.
And that gets back to what is the advertising idea at issue here? And again, I submit that it's public domain use of celebrity endorsements. It's been going on before our lives. And yet, they can't find one case, they could not cite to this court one case that held that an advertising idea, that an athlete's name being used to endorse any product constitutes an advertising idea.
Let me just, I mean, if certainly if Michael Jordan, if they named their shoe the Jordan, and if Michael Jordan simply said, I want you to be paying me for my name, and there had been no other shoes named Jordan, it would purely be a personality, purely be one that would be within the realm of a personal use of the name. He would be saying, I want you to pay me for the use of my name.
It's a publicity right.
Okay.
It's a property publicity right.
But where Michael Jordan says, I have a set of businesses called Jordan, and I use my name for those businesses, doesn't it at least mean that there's a second claim, which is, I am using my name for advertising for my businesses with the Jordan name, and now you are using that same name for that purpose?
I don't believe it is, Your Honor, because if you look at the case law and the analytical concepts that are used, and we were criticized for talking about secondary meaning cases, but that's all the case law they relied on was about secondary meaning cases. It still is a property right of Michael Jordan in the publicity value of his name. It's not that they stole whatever. Had they gone into a similar business, so to speak, let's say he had restaurants and they opened up Michael Jordan restaurants, and he had trademarked Michael Jordan restaurants like Joe Theismann did for steakhouses, that can be an advertising idea because now the celebrity has himself associated and created a business tied to his name, and I'm going to sell steaks using Joe Theismann. But that's not this case. There's nothing that even approaches anything the Bekilas did with what Vibram did, except for the use of the single word Bekila, the surname. And again, they're not complaining, hey, you took away any of our business. They're not complaining, you took our advertising idea and now you've stolen our business. They're saying, our father's name has value, we have licensing rights, you used it without getting the license for the endorsement. And that's a publicity right, that's a property right, and that's why it's not an advertising idea.
What about Nissan, the word Nissan from the case, that one word, and that's advertising idea?
Number one, it isn't a person's name, it's a registered trademark, and the evidence was that Nissan had so penetrated the market and its name was so well known in so many contexts that when the website operator started using the name to sell its own advertising and products, including automotive products, that was found to be a procurement of an advertising idea, which was a trademarked business name. Not the case here, nothing even close in those
What
facts.
about paragraph 25? It seems like paragraph 25 in the amended complaint, it has two parts to it. Since Bekila's passing, the Bekila family has sought to protect his personality rights and intellectual property from any, that part I agree is with your argument on. But then it goes, additionally, by their commercial uses, sponsorship, and promotion of historical and education events, multimedia events, the family has intentionally associated their family name with Aditi Bekila's barefoot dedication to succeed under any circumstances. Isn't that a marketing statement? A barefoot?
But it's what are they associating with the name? They are associating with his name a character trait, his barefoot dedication to succeed under any circumstances. That's not a product, that's not an advertising idea.
But it says commercial uses. By their commercial uses, they've intentionally associated their family name with barefoot dedication to succeed under any circumstance. To me, that's just what these guys are doing,
But
isn't it?
you could apply the same thing to any endorsement case, Your Honor, because if Movado now wants to go after Tag Her because Tom Brady, they were the first ones to use Tom Brady, they would come and say, oh, you know what, you took our advertising idea, you're using Tom Brady. It doesn't work because it's an endorsement.
They're not calling it the Tom Brady, though. These guys are calling it the Bekila.
No, I understand, but they're using his image. They're adopting his persona to sell.
Right.
So nobody doubts that it's Tom Brady on the billboard next to the watch. And you got billboards with Movado watches, you got billboards with Tag Heuer. that wasn't an advertising idea that was stolen. The advertising idea was, let's use him to endorse our products.
But it's Barefoot, it's the Barefoot Association. It's not just his name, it's Barefoot, his name, and, sports,
But I understand that, Your Honor, but what I'm saying, the commercial use is the endorsement, and that's, I believe.
So, but we're sort of losing track of where we are, though. I mean, that may well be, but we're not deciding who's going to be successful in the trial in Washington State, which I think already took place. I mean, it was already dismissed. The issue is whether or not there's coverage.
That's right, Your Honor, and again, that's why I say the evidentiary record are these 2 pages, essentially, with maybe the following.
But it's not even whether there's coverage, it's whether there's a duty to defend, which is just adumbrate a claim, right? That's our language, sketch out a claim.
Yes.
And this doesn't sketch it out.
Your Honor, Judge Kaplan looked at it and said it didn't, and I believe he's correct because, again, even if you put all this together, you do not see the Pequila family articulating an advertising idea that was taken from them by these complaints. Yes, they used his name commercially. It was their father, he was famous, they wanted to honor him, they had a store in his name, they wrote books about him, they had a movie about him, they have a website promoting his history, his life.
They had a commercial.
Pardon me?
They had a commercial.
And a commercial. And that was a license they gave to Pepsi for the Olympics. I think it was in Atlanta. Pepsi came to them and said, can we use your dad's likeness? We want to run a Pepsi commercial featuring a B.B. Pequila. Wrote them a check. They said, fine. And that's what they're saying Vibram didn't do here. And that's all they're saying. They're saying that we own that.
I think your time is well up.
Well over,
so
yes, Your
thank you. Mr. Reisberg needs to argue just in the event that you
confine
do
myself
prevail, actually.
to the recoupment issues. Thank you. May it please the court. Just with respect to the recoupment issue, the insurers do not disagree that the duty to defend is broader than the duty to indemnify, and that if there was a duty to defend here, then the insurers would not have a right to recoup.
Obviously,
we
if
don't.
you have a duty to defend, then you have a duty to defend.
Yeah, and we wouldn't.
So your argument depends upon your brother prevailing to say that you don't have a duty to defend.
Without question, and those are the only. That is the premise of our claim for recoupment here, is that we're seeking to recoup defense costs that were never owed. And to illustrate that distinction, I think the trial court properly found here that if the insurers had not agreed to defend Vibram under a reservation of rights to seek to recoup these defense costs, the insurers would not have incurred any legal liability for their failure to do so, because they never owed a duty to defend Vibram. And that follows necessarily from the trial court's determination, which we're asking this court to affirm, which is based as a matter of principles of contract, a contract alone, that the allegations in the underlying complaint are not reasonably susceptible of stating a claim that falls within coverage.
But isn't a reservation of rights essentially a declaration by the insurance company that there is uncertainty as to whether there is a duty to defend, and that you will be a good doobie and you will defend the claim until there is a declaration as to whether you have a duty to defend?
And Your Honor, in the Morrison decision, where this court made reference to that so-called prospective termination rule, that an insurer in a declaratory judgment action can only extinguish the duty to defend prospectively, but not retroactively, the court, in its very next sentence in Morrison, explains the limited context in which that prospective termination rule applies. And that's where the duty to indemnify turns on a disputed question of material fact.
But here it
So that not until that
here it depends upon disputed issues of law, but it's still disputed issues.
Well,
There was
it's-
still uncertainty, otherwise you would have said you're on your own.
No, but in certainty as to how a court is going to interpret policy language is very different than uncertainty over a yet undecided question of fact. Because where a question of fact is yet to be decided, it can properly be said that the duty to defend should remain until that question of fact is resolved. But in a case like this, where the court decides as a matter of contract interpretation that the allegations in the complaint were never susceptible of stating a claim within coverage, that's not conditioned on anything occurring. That determination exists, independent of time, if you will. It exists whether the court made the determination or not. It means necessarily that duty to defend was never owed. And so I think that demonstrates the false premise on which Vibram's entire opposition to our claim for recoupment is premised. Vibram repeatedly argues that the insurers were trying to avoid the contractual obligation that they had here to defend while there was uncertainty over coverage. But there never was a duty to defend triggered here, and that is illustrated by Judge Kaplan's proper observation, that if the insurers had never agreed to defend Vibram, they wouldn't have incurred any liability for the failure to defend because they had no duty to defend.
So if it's a really tricky question about whether they have a duty to defend or not, and you defend, you're entitled to everything back, all the money, even though you've gotten to defend. I don't know. It just seems like very tricky. And also, other thing I'm wondering about is the slow paying. So you agree to defend, and then no one pays you, right? No one pays for this stuff. But then we're encouraging people not to pay, aren't we?
I think a rule that denies an insurer the right to recoup defense costs that were never owed would clearly discourage insurers from doing something this court has long encouraged insurers to do, which is defend their insureds under a reservation of rights and to seek a judicial declaration that a defense was never owed. And only where the insurer can establish, as I believe the insurer has established here, that a duty to defend was never owed as a matter of contract interpretation, then the insurer should be allowed to recoup the defense costs that the insured received and is never entitled to under the policy. If the insurers are right here and that there never was a duty to defend, then it can't be credibly disputed that Vibram's ability to retain these defense costs will be the retention of a benefit that it was not entitled to under the contract,
Well,
and for which it did not pay a premium.
And what if Vibram was not a corporation, but a poor slob who couldn't possibly afford to pay?
Well, that goes to the wisdom of the court's ruling in the Cotter decision and that framework that this court recognized in Cotter, which was to opt away from adopting a hard and fast rule which would prevent an insurer in all circumstances from relying on principles of unjust enrichment and restitution to seek recoupment, and instead to leave it to the courts based on the equities and the facts in a particular case to distinguish the circumstances in which, as in our case, I believe that recoupment is warranted from a case in which the equities would suggest that recoupment is not warranted. So it's not difficult to imagine a case in which the insured is not a sophisticated corporate entity like Vibram, okay, but instead an individual or a mom and pop store who can demonstrate that because they didn't have the means to do so, they wouldn't have paid for their own defense, let alone a judgment against them. In that case, just as in Cotter, okay, the court would be warranted in finding that based on the equities here, maybe the insurer should not be able to recoup defense costs.
But there is some virtue of clarity here, because if you're right, then we're going to be litigating every recoupment case, because everyone, you're going to say you have an obligation to recoup, and they're going to say I'm a poor slob, and it would be unjust to do so, and we're going to have to make an equitable determination. So we're going to be litigating all this stuff. Don't we need something
But the alternative, Your Honor, is really to present the insurers with the true Hobson's choice. That is two real untenable alternatives.
Isn't that
okay?
what happens now? I mean, does anybody really seek recoupment? I mean, if you did, wouldn't we be seeing it before today?
But why put insurers in the position, in a case like ours, where Vibram incurred $1.3 million in defense costs, and they did so knowing that the insurers intended to recoup those defense costs if they obtained the declaration that a duty to defend, was never known? Why should an insurer be forced with two untenable options? One is, to pay defense costs that they don't owe under the contract, and not be able to recoup those defense costs.
And if
the
you're worried-
alternative
if the
run the risk
insurer-
of bad
about
faith.
that, the insurer can say in the policy that we will seek recoupment if a duty to defend is found not to be owed, and it could say in the reservation of rights letter that we will seek to recoup. Did your reservation of rights letter speak of that here?
And we said that here, absolutely. We said
policy.
expressly in the reservation of rights
Not
letter.
in the policy.
But not in the policy. Okay.
Does Goldberg suggest it should be in the policy?
Well, Carter clarifies that there is nothing in Goldberg that precluded the insurer's right to seek recoupment of those indemnity payments, despite the fact that there was no express grant of recoupment under the policy. So this court's prior precedent already recognizes that it doesn't need to be expressly granted. There's a good reason why. These defense costs weren't paid under the policy. If they weren't paid under the policy, why do we need to look to the policy to grant the insurers the right to recoupment? Vibram argues that we're the ones that are trying to rewrite the contract here. Let's at least recognize that we're the ones that are trying to enforce the contract here. Vibram is trying to rewrite the contract by retaining a benefit that is undisputed it was not entitled to under the contract, and for which it never paid a premium.
So this is where I'm having a little trouble, and I'm reticent to say anything about Monday morning quarterbacking, but the issue of duty to defend is easy to see afterwards, after the declaratory judgment. So what if there's a lot of uncertainty regarding the issue, and the insured has to decide what to do, and then the case gets litigated, and in fact, there's no coverage under the policy, but it was real close call.
So, in this rule, better insurers than insurers are going to do the right thing when it's a close call. It's not going to penalize them
But that's
for
an ad
defending
hoc-
under a reservation of rights, and only if they can determine that a duty to defend was never owed, then they're going to seek to recoup.
The problem with that is what Chief Justice Gantz is saying, is there's a lot, first of all, there's huge uncertainty as it relates to serious litigation decisions and business judgment. But secondly, there's no hard and fast rule, and we're going to have lots of litigation in trying to figure this out.
Well, I mean, I think that the beauty of the decisions in Carter, that the court's decision in Carter was not to adopt a hard and fast rule that would create a roadblock that would apply solely to an insurance company's claim to recoup defense costs. And it would say to an insurer, we're going to deny you the right to rely on these well-established principles of unjust enrichment and recoupment that are available to any other business or any other person in law. But when it comes to an insurance company, we're just not going to let you rely on it.
There's
Why?
a third way for the insurers, right? They can just choose not to defend and risk a 176D claim, right?
Right. And
So
why?
so there really is three options. You can say, okay, this is a clear-cut case, we're not going to defend. Or, that's option one. And option two, this is damn close. We're going to control the defense as best we can. No? Okay, that's okay.
We're not allowed to control the defense.
Okay.
This distinguishes
That's
us from Jerry Sports in Pennsylvania. That was important to the court there, including that the insurer shouldn't have the right to recoup. They
Fair
said the
point.
insurer got to defend and control the defense. In Massachusetts, when we issued a reservation of rights, we exercised no control over the defense. We were just sent $1.3 million worth of invoices and asked to reimburse them promptly. And we were sued for bad faith because we didn't do it quickly enough.
Okay, thank you.
Thank you.